Now we will be dealing with the crucial aspect of lawmaking. What actually happens? So we have seen that legislature is vested with the exclusive authority of making the law. So we have seen that the Union Parliament will make laws on the subjects as mentioned in the Union list as well as the subjects which are mentioned in the concurrent list, which is given under the 7th schedule of the Constitution. So there are ordinary bills which can be placed before either house of the Parliament and which may require simple majority or special majority. Then you have money bills which can be placed only before the which can be introduced only in the Lok Sabha, and then we have the constitutional amendment bill which can be introduced again only in the Lok Sabha and which requires special majority to become the law. Now we will see actually what happens when any of this kind of bill is placed before the house or introduced before the house. Now the first thing which happens is the journey of a bill. Now we have to see, as a student we must know how the laws are made. We know that the lawmaking authority is the legislature, but how? What is the procedure which they actually follow? Now the first step in the journey of a bill is drafting of a bill. Now the bills are usually drafted by the government. You have an expert committee which consists of the experts from various fields, the concerned domain area. For example, they are making a law on biodiversity. Then you have the committee experts, that is the botanists, biologists, the other persons who are very well versed with the biology. Then also you have the legal experts who can mold those concepts into the legal this thing. You have specialized persons known as legal draftsmen whose job is to carefully word and prepare each and every clause of the bill. Sometimes what happens is, other than the government, you have members of parliament placing certain bills, also known as private member bills. So they can themselves draft that particular bill and introduce. However, the private members cannot place a money bill or constitutional amendment bill. They can only go with the ordinary bills. Then the step 2 in this particular purpose is introduction. Now once a bill has been prepared, it will be introduced in either houses of the parliament. That is, either it is introduced in Lok Sabha or it is introduced in the Rajya Sabha. As I told you earlier, ordinary bills can be introduced either in Lok Sabha or in Rajya Sabha. However, money bills can be introduced only in Lok Sabha, that too with the prior permission of the president, and also the constitutional amendment bills can be introduced only in Lok Sabha. So ordinary bills can be introduced in either house of the parliament, whereas when it comes to money bill or constitutional amendment bill, they can be introduced only in the Lok Sabha. That is the second step, which is also known as first reading, First reading, what happens is, the bill is introduced in the respective house. Now we will see what happens in the second phase. Third step is the second reading of the bill. Now in second reading of the bill, a detailed discussion will be held on the various clauses of the bill. Each and every clause of the bill will be discussed in detail. Then possibly, for example, if a particular bill contains certain provisions which are very crucial in nature or which have wider implications on various sectors of the economy or various sectors of the public, then in that particular situation, that particular bill will be referred to a committee, popularly known as standing committee or joint parliamentary committee. So standing committee consists of members of both Lok Sabha as well as Rajya Sabha and also the experts. So they will go through the bill. They will suggest what are the changes, what are the modifications, if any, or whether the bill should be retained in the same form. And now the step 4 is the committee report. Now what happens in the step 4 is the most crucial part of the bill. In step 4, we will see that the committee, the standing committee which has gone through these kind of bill and various provisions of the bill, first what they will do is, they will constitute a group of experts who will go through each and every clause of the bill. Now after that, after they have gone through each and every clause of the bill, They will see what are the pros and cons of that particular provision, and after noting that pros and cons of that particular provision, they will ask the experts to give their opinion, suggestions, modifications or any kind of objections. Those objections, etc. and suggestions, modifications will be discussed, and what is the conclusion of that particular standing committee will be clearly written and incorporated into something called as standing committee report. So, in the standing committee report, what actually happens is the experts review, depending upon the nature of the law or the type of the law which they are going to introduce. Here the experts will vary. If it is concerning science and technology, you have scientists. If it is concerning any kind of particular law, then you have legal experts, sociologists, political scientists, etc., who will sit and they will prepare. Recently, we have seen committee reports being prepared when it comes to the new criminal laws, that is 𝗧𝗧𝗧 𝗚𝗧, Bharatiya Nagrik Suraksha Sanhita and Bharatiya Nyaya Sanhita, BNS, BNSS and BSA. So, criminal laws amendment, you can see that entire Joint Parliamentary Committee had given 3 different reports which in detail consisted of various aspects of the newly introduced reforms. Then they also suggest modifications in certain cases. If the bill which was introduced requires some kind of modifications or some sort of changes which are very much essential or very much necessary to contain the various problems which may arise in its implementation, in that particular situation, what they will do, they will suggest any kind of modifications if need be. Then again, the government is not under obligation to go by the modifications as suggested by the standing committee. Usually they go by it, but there is no hard and fast rule that the government shall follow the recommendations of the standing committee. It is usually followed. Why? Because it consists of the already members of parliament who are there within the ruling party as well as the opposition. So, there won't be any much discussion after the standing committee report has been given. Why? Because the detailed analysis is done. Now, this takes us to the next phase, that is step 5, that is the third reading. Third reading of the bill, which is also known as final reading. Here what happens is final discussion will be conducted and voting will be there in the house. So, final discussion will be conducted as to what are the various aspects which are there in the bill. Now, what are the different legal implications of that particular bill and whether it needs any kind of modification or not. So, what they will do after incorporation of different modifications as stated by the different MPs from time to time, each and every clause will be put to vote. And once a clause has been put to vote, first they will see whether that particular clause stands the part of the bill or not. Then they will ask the Speaker of the House or the Chairman of the Rajya Sabha will ask the members to move that amendment. And then again each and every amendment is put to vote. If that amendment has been passed by the House by majority, then that amendment will be incorporated into the acts or modifications will be incorporated into the acts. However, if there is no majority in favor of that particular amendment, it will not form the part of that particular clause. Then that clause will be passed. So, clause by clause, each and every clause will be passed. However, due to certain restrictions of time, usually what happens is the entire sections, the entire chapters are put to vote. And sometimes what happens, the entire enactment, the entire bill will be put to vote at once. All the sections will be put to once due to the certain paucity of time. So, in that particular method is known as guillotine or guillotine. In that particular method, what they will do, they will put the entire sections of the enactment for the purpose of voting, and basing upon the majority, it is deemed to have been passed by that particular house. Then it goes to the next house and they will go through the first reading, second reading, third reading if need be. And if it is passed, it moves to the other house, that is Lok Sabha or Rajya Sabha, for the same process. So, the process is same in both the houses. So, what happens is once standing committee has given report, there is not much big process left in the second house. Why? Because the standing committee itself consists of members from both the houses of the parliament. So, therefore, there won't be much opposition when it comes to the introducing the bill after being passed from one house to the another house. So, we will see what are the other aspects. The sixth and the most important aspect is President's assent. As we have already seen that until and unless the President of India gives his assent, the bill, even though it has been passed by both the houses of parliament, will not become the law. So, if both the houses of the parliament approve, then the bill is sent to the President for approval. Now, once the President signs it, it becomes a law. Once the President of India signs it, it becomes a law. And then remember, the President can withhold or return the bills for reconsideration. So, since he is the ultimate authority when it comes to giving assent to the bill, if he feels that there is some provisions which are not up to the constitution or may not be constitutionally valid, in that particular situation, he can withhold his assent. He can withhold his assent. That is, he can simply remain silent. He can simply remain silent, also known as pocket veto. Pocket veto means simply he will put that bill aside and he will not give any kind of assent. So, he can do in certain cases, or he can return the bill for reconsideration. He can send back the bill to the houses for reconsideration. However, when it comes to money bill, he cannot return it. Why? Because it was in fact the President with whose permission that money bill was introduced. It was with the prior permission of the President only that the money bill can be introduced in the Lok Sabha. So, since he has already given assent, so there will not be any chance for the President to return the money bill for reconsideration. And the same thing is with the constitutional amendment bills also. If it has been passed by both the houses of parliament, then the President has no other option but to mandatorily give his assent. And once the assent has been given, that power to give assent or not is known as presidential veto. If he doesn't give or if he withholds his assent when it comes to the ordinary bills, then it doesn't become a law until and unless it has been assented by the President. Or if it has been returned, that is, ordinary bills can be returned, and again if it has been passed by both the houses, then in that particular case he has to give his assent, and money bills and constitutional amendment bills cannot be returned for reconsideration. So, technically he can withhold the assent, but he won't. Why? Because it was with his permission, prior permission only, money bills and constitutional amendment bills can be introduced in the Lok Sabha. So, this takes us to the next area, that is implementation. Now, what happens actually is the implementation of the law. Mere passing of the law or mere passing of the law from both the houses of parliament and obtaining the presidential assent is not enough. Obtaining presidential assent is not enough, and that new law has to be communicated to the public. Then the question is, how will you communicate the new law to the public at large? How are you going to communicate the new law to the public at large? That is the question. So, now in this particular era you have social media, etc. But the thing is, it has to go through the formal means. Now, what are the formal means? The only formal means which is there for the government of India is to publish the law in the official gazette. Publish the law in the official gazette of India, which is the official newspaper of India, you can say. So, in the official gazette of India, as soon as that particular law has been published, it is deemed to have come into force. However, sometimes certain laws which are very crucial in nature, they themselves specify as to on what date the law will come into force. They will clearly specify as to on what date the law will come into force, or sometimes what they say is the central government may by notification specify from what date the laws will come into force. So, usually it happens in the cases of laws which are radically going to change or which are going to have critical implications on the public at large. So, here we will see that implementation part will be done only when the Gazette notification is given. Even after Gazette notification is given, the date of enforcement or commencement should be taken into consideration. Even after date of commencement, there should be certain on-ground rules which are prepared for the implementation of that particular law. Whenever we are speaking about on-ground implementation of that particular law, we shall see that it is the executive authorities who will ensure the on-ground implementation of that particular law by preparing different rules, notifications, bylaws, etc. But nevertheless, all these notifications, bylaws, notices, circulars, etc., they form the part of this particular law, and ultimately they should be in consonance with the Constitution. Why? Because if these kind of notifications, rules, bylaws, etc., if they are not there in consonance with the Constitution, then what actually happens is it is likely to be struck down by the courts of law as being unconstitutional. So, the law-making process which we actually see is derived from various stages. For ordinary bill, there need not be any kind of special procedure. Usually, it is introduced in either house of the parliament, and it may be passed with simple majority or in certain cases special majority. But when it comes to the money bill, special provisions are there. Why? Because it has certain kinds of financial obligations. And then when it comes to the constitutional amendment bill also, there is a special provision, that is special majority is required, and it can be only introduced with the prior assent of the President of India, prior approval of the President of India, and then 2/3 special majority is required. And however, if the constitutional amendments touch upon the federal feature of the Indian Constitution, then it requires not only the special majority of both the houses of the parliament, but also ratification by not less than 50% of states in India. So, not only 2/3 majority of each house of the parliament, but also 50% of the states should say yes to that particular amendment, then only it can be done. So, recently we can see that GST amendment was done in this particular manner, that is special majority along with the ratification by the states. Now, once the laws have been passed and they have been implemented by the executive, there are certain disputes which are bound to happen. There are certain grey areas in the laws which may need interpretation. So, when it comes to the disputes coming to the implementation of that particular law, or disputes arising out of interpretation of that particular law, or giving plain meaning to that particular law, there comes the next branch of the government, which is known as the judiciary. The judiciary is the third wing of the government, which is vested with the power of ensuring proper interpretation of the law and to ensure that there are no disputes between the parties. So, the job of the judiciary is to judicially resolve the disputes between the parties. The parties may be two individuals, or the parties may be individuals or the government on the other hand. So, this takes us to the next crucial branch, or you can say one of the most important branches of the government, that is the judiciary. So, now we will see how the judiciary is organized in India. Now, the judiciary, whenever we are speaking about the judiciary, first we have to look into articles 122 to 147. 122 to 147 speak about the Supreme Court of India. The Supreme Court of India, which is the highest court in the land. There is no other court in India above Supreme Court of India, which is situated at Delhi. So, articles 124 to 147 of the Constitution of India clearly speaks about establishment of Supreme Court of India. Then it fixes the number of judges, what is the composition, how the judges are to be appointed to the Supreme Court of India, what are the different powers which are enjoyed by the Supreme Court of India, and what kind of superiority it has over the other subordinate courts and also the high courts in India is clearly laid down in the articles 124 to 147. Now, this is at the union level. At the state level, you have high courts. At the state level, you have high courts, which are discussed under articles 214 to 231. So these articles speak about the establishment of various high courts at the state level, then the powers of the high court, then the composition of the high court at the state level, and the subordination of subordinate courts to the high court. So it is clearly mentioned under articles 214 to 231. Then we have articles 233 to 237 speaking about the subordinate courts, that is the local level courts up to the district level. So the bare minimum organization is given under the constitution. The wider implications are given under the respective state enactments. Why? Because the subordinate courts are organized in accordance with the state legislations. That is, the state government will make the own set of courts when it comes to the subordinate level. However, at the state level and at the central level, you have high courts as well as the Supreme Court of India, whose powers, jurisdiction, etc. is clearly defined under the constitution. Now, the objective of giving the powers upon the judicial branch of government and to recognize it as a separate one is for the following things. One is ensuring justice, to ensure that the justice is given to the poor and also the needy. So whenever delivering of justice is there, the courts do not make any kind of difference between either rich or the poor. Then you have protecting the fundamental rights. It may so happen that in the wider functioning of the state mechanism, you may have the executive or legislature which may try to take away the rights of the people as guaranteed under the constitution. In that particular situation, the only hope which is left for the people is to go and knock the doors of the court. That is where the judiciary enters and tries to protect the various rights of the public at large. Then you have interpreting the constitution. When there is a tussle or when there is a rift between the executive and the legislature, it is actually the judiciary which sits as the interpreter of the constitution. It will interpret the various provisions of the constitution to ensure that the system of checks and balances is followed in the society. So here what we have seen is, in India we follow something called as single integrated judiciary. Unlike the division of state legislature, union parliament, state executive and union executive, you don't have such kind of division. So here we follow single integrated judicial system in the country. And this particular system is a three-tiered system. That is, you have Supreme Court at the national level, single court, you have high courts at the state level, then you have subordinate courts which consists of district and lower courts at the local level. So the judiciary acts as the final interpreter of the constitution. If there are disputes between two rival parties, then it is the job of the judiciary to resolve those disputes in the terms of the laws made and finally, ultimately, in terms of the constitution which is being enforced in the land. So the judiciary plays a crucial role as an arbiter between the arbiter in the disputes between the various parties and stakeholders. And in fact, you can say that the judiciary plays a crucial role of watchdog of democracy. It plays a crucial role of protector of the fundamental rights of the people. In a democratic society, it is essential that you have free and independent judiciary which is going to take care after the disputes which may arise in the implementation of the law. Always remember, even though good laws or bad laws, there is no such thing as a good law or bad law. It all depends upon the implementation of those laws. And definitely whenever there is an implementation of law, there is a question of disputes, and those kind of disputes can only be resolved by the judiciary from time to time. So in India, we follow a single integrated judiciary right from the local level till the Supreme Court of India. So unlike the other federal polities where you have the state supreme judiciary and the federal supreme judiciary, here we have a single track of judiciary which goes from local courts to high courts till the Supreme Court of India. So the judiciary has been organized into the three heads right from the district level till the Supreme Court of India. So the judiciary acts as a final arbiter in disputes between the various stakeholders. And in a democracy, it is essential that you have free and independent judiciary. Why? Because democratic system depends upon the implementation of the laws and finally the protection of the constitution. So, in order to protect the constitution and in order to avoid any kind of disputes in the implementation of law and legal provisions, judiciary plays a very crucial role.